Hey folks, this is Rob Wells here with you from the Law Office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, we're going to talk about the no-fault just cause for terminating a tenancy to allow the owner or their qualified relative to move in to the subject property. Before I begin though, landlords, property managers, if you're dealing with a situation where you might be contemplating moving into your rental unit or having a qualified relative move into your unit, please feel free to reach out to us below. Now, let's begin. Now, I'll tell you this, we probably have done a lot of these types of terminations of tenancies over the last 2 years. As many of you may know, from the COVID-19 pandemic, evictions were heavily restricted, and we had a lot of landlords and property managers acting on behalf of owners, changing their living situation, such as moving out from the cities and moving to a more suburban type place. There was a lot of work from home, and this type of eviction was quite common, and it still is for a lot of people. But the questions I get about this is, Rob, what qualifies as an owner move-in eviction, or what type of relatives can move in? And that comes straight out of the Tenants Protection Act under Civil Code 1946.2. The code says that the owner, their spouse, a domestic partner, their children, grandchildren, parents, or grandparents can qualify for this type of termination of tenancy. So that means, hey, if you wanted to move your brother or sister or a cousin, if you're subject to the Tenants Protection Act, those relationships would not qualify for that type of eviction. And also in the Tenants Protection Act, there are a couple of terms and conditions as well too, particularly if your lease was entered into on or after July 1st, 2020, if it's a regular residential lease, or starting July 1st, 2022, if the tenancy is for a mobile home, because the legislature amended the Tenants Protection Act in 2021 to include mobile home type tenancies. So now they're subject to the same schemes now. So what you have to have in your lease, if your lease is a new lease entered in on or after July 1st, 2020 or July 1st, 2022, is you actually have to have a term in your lease agreement that allows for this type of termination of tenancy. Now, there is a catch, there is a carve out in that if your lease doesn't have this provision, you can actually ask your tenant at the renewal of the lease to include a term of, to allow you to terminate the tenancy for this. Or you can, if your tenancy is a month-to-month tenancy, you can ask your tenant to sign an addendum adding that term to the lease. Because if your tenant doesn't cooperate with that process in the Tenants Protection Act, that is just cause for terminating the tenancy. They did allow this exception because it actually has to be in writing. Now, renewals of a lease, it doesn't require that. So if your lease was entered into or your tenancy began before July 1st, 2020 or July 1st, 2022 for mobile homes, you can just outright just give a termination notice with the cause being you're moving in yourself or a qualified relative. Now, you also could get the consent of the tenant to agree to this type of termination of the tenancy, but I probably, unless you, really had, like a really great relationship with your tenants and they were going to move anyway, you need to have this provision in your lease agreement if you're a post July 1st, 2020 lease. So it is possible to, to move in yourself or a qualified relative. And like I said in the other video, if you do a termination of tenancy for this no fault just cause, you will have to pay your tenant 1 month's worth of rent and elect how you're going to do that in the notice. There's only 2 ways you can do that right now. It's either within 15 days after you give your notice, you elect to pay your tenant a direct cash payment, or at the end of the termination notice, let's say it's a 60-day notice, you have to tell them, hey, your last month's worth of rent, we're going to waive that. And there are no exceptions to this. One tip that we always run into when a landlord's subject to this type of tenancy is if you're waiving the last month's worth of rent, you need to have the notice expire with enough time to allow that 1 month's worth of rent. So if your rent payment is on the first of the month, you have to basically allow enough time in your 60-day notice. For this example, you have to make the tenancy expire at the end of the month, and that you may actually give your tenants a little bit more than 60 days notice, but just because of the way the Tenants Protection Act is written, it's probably best that you make the termination notice expire through the end of the rental period if you're going to waive last month's rent. If you want to terminate the tenancy mid-month, and hey, 60 days, that ends up being like on the 15th of the month type deal, you're probably best just paying the direct payment. You won't have that issue. So folks, if you're running into this type of situation and you need help trying to figure things out, please feel free to reach out to us below, and we'll see you next time. Thanks.